any supervision will imply interference. The question is, does it colonize the other person's power? Does it destroy the other person's power? Does it violate the principle of the independence of...
Where the parliament has made a law that destroys the existing rules, what does it do? It
My
does
lord,
destroy.
it doesn't destroy the existing. Now that is a question which I will address. Relationship, अगर मैं सिर्फ competence अगर खत्म कर लूँ अपील की हद तक, मैं अपील की हद तक क्योंकि I
एक क्वेश्चन मेरा जरा ऐड कर लीजिए थोड़ा सा.
जी.
Article 191 says subject to the constitution and the law. So what does that mean? The powers given to the Supreme Court by the constitution are absolute, or is there still a room for interference? Interference means amendment, or
I would not like to use the word interference because it gives...
It's not interference, yes. I'm sorry for that.
I would say that your lordship...
But still the rules are, the power which has been given to the Supreme Court, is that power absolute?
No, it's not absolute.
Because the first word is subject to.
Yes. Subject means conditional. It is a restriction. It can't take over the power to take rules. It can't paralyze that. That is why I would say that the Supreme Court should be insulated from external pressure. It should not be isolated. So Article 191 creates this balance where the internal autonomy of the Supreme Court stays in the hands of the Supreme Court, but subject to certain restrictions which may be imposed, and certain conditions which may be imposed by Parliament. I'll come to, because this is a crucial question, and there is a Supreme Court judgment on this, the relationship between rules and act and what prevails. I'll come to that.
If I've understood you correctly, what you're saying is that this is not this law-making power, or law as in 191 is not a fully enabling power, but it is a power of a supervisory nature. Is that what you're saying?
It is a restrictive power.
You use the word supervisory.
Yes, I use the word supervisory in terms of that it is a power which has its limitations. That is why...
One reason why I'm asking this is because you're emphasizing on linking this with entry 58.
Yes.
Which you say should be interpreted in the usual way that the legislative entry is normally interpreted.
Yes.
That would seem to necessarily imply that whatever is the subject matter of that legislative entry, it is not as such disclosed in 58, but I imagine would then be the practice and procedure of the Supreme Court. Then surely, if you read it the way you are linking it, then that would, the law-making power would cover the whole of the field of the practice and procedure of the Supreme Court, and thereby, just hang on, thereby become an enabling power and not remain a supervisory or restrictive power of the nature that you are now stating. So there is this tension between what you are saying, a possible conflict. Kindly clarify this point.
My lord, there is no conflict because the language of entry 58 clarifies. Entry 58 cannot go beyond the conferment of power with necessary implication which any article of the Constitution does. So any power in terms of legislation which entry 58 does must be in the context of the power conferred by the Constitution. So if 191...
But that power, in the end, legislative entries confer power, legislative competence over a subject matter.
Yes.
A tax on income.
Yes.
The defense forces, international relations, what have you. The entry 58 of itself discloses no subject matter as such. It simply refers, because this is the point.
That is why it is limited by that constitutional provision which confers this power.
Then how do you read it as a legislative entry? Because if you now link it to the subject matter of practice and procedure, that then should...
Sir, if you don't read it as a legislative entry, you will make part of the entry redundant. The part of the entry says or relate to the federation.
And that's what I'm saying. That
I mean, it makes it redundant.
No, it doesn't make... That's my question to you.
Yes.
Aapki jo submission...
I'm sorry, sir.
that seems to me not to be restrictive or supervisory. That would necessarily, if you link it to a legislative entry and the manner in which legislative entries are interpreted, that would have to be given the legislative competence, the power to make the law, the enabling power, whatever you want to put it, would, it seems to me, have to be interpreted in the broadest possible manner, which would mean that it would cover the whole of the field of practice and procedure, which is why Mr. Salahuddin, for example, said that yes, the Supreme Court rules can be repealed by an act of Parliament.
No, I don't take that.
Don't go there.
No,
I understand.
I don't
That's
take
why I'm asking you.
Yes.
So there is this tension
Yes.
between linking it to a legislative entry, because that's how legislative entries are interpreted, and then in the same breath or in the next breath saying that no, it can't go to the full subject matter. It is restricted to supervisory or limited nature. And
My
how
lord,
do you draw the line?
these are entries which I call ping pong entries, and I'll explain when it come to.
Mr. Faisal,
Ji.
taking the discussion further, and that's very important, what's being discussed. My understanding is, what appears to me so far is that when we have to read 191, straight away when you look at 191, there could be a restrictive meaning given to law, but we don't have to really stop there. We could also say that there could be a law, even plain reading of 191, that there could be a law that would cover the area of practice and procedure, because that's why to that law. There is a law, whenever Supreme Court goes ahead and comes up with rules, it will look at law. There could be laws relating court fee, there could be laws relating to many things that impinge upon, but at the same time there could be a law which takes care of the whole area of practice and procedure. But when you read it with 58, it does, as my learned colleague also mentioned, makes it very expensive. It says that it covers, it is the subject matter that we'll have to look at. And it appears that when 191 is read with 58, the entry, it appears that there is legislative competence with the Parliament to legislate on the question of practice and procedure. So hence, perhaps what Mr. Salahuddin said, that it can abolish the Supreme Court rules, appears to be then correct. You can't stop halfway. You have to either accept the whole contention saying that 58 read with 191 gives the legislative power, and then in that case they can go ahead and do whatever they want to do regarding the rules. So that's one. So, but what appears to me is that if 191 is read after reading 58 and you come back to 191 after reading 58, then you look at the legislative competence only, and it appears that then law, when you look at law then after 58, it appears that it gives you that legislative competence.
I bow to your lordship. That is why I said it's a ping pong entry, and that is what happens when you look at entry 55. My position is very different from Mr. Salahuddin's position.
Ping pong can go on endlessly. Where does your ping pong end?
I'll come.
I think it's just one way. It doesn't go back again to the entry
One
again.
thing would do.
But one more question that I want to add here, maybe you can respond to that also. Is there a difference between the word practice and procedure? Because one would have understand that it could be a procedure of the Supreme Court. What's the importance and significance of the word practice? And I say it for a reason. I say it for a reason because there are judgments of the Lahore High Court while discussing letters patent, saying that this is an internal arrangement in the, they don't consider it as an appeal. They consider it as an internal arrangement of the court, as if it were to pass for a practice. So considering that case law, written by celebrated judges of our courts, the question is, could it then be said that considering that it's an intra-court appeal, it's not an appeal in the appeal sense. That's exactly what the judgments say. It's not an appeal, it's an internal arrangement of the court. Could it then pass under the term practice under 191 to have this intra-court appeal? As you had mentioned earlier, so that's why, is there any significance of the word practice and whether intra-court appeal passes for an internal arrangement of the court and not to be considered as a substantive separate appeal?
My lord, this is a question which to a certain extent has been answered by an opinion of Justice Munib. And I'll straight away come to that. Those are three. There is a short order by Justice, it is Justice Mando Khail who actually raised this very important issue through a short order. And then there are two opinions, one by Justice Hassan Azhar Saab one by Justice
You
Munir.
might consider these 3 judgments of the Lahore High Court
Yes,
also,
I
which
can.
are...
But let me just read those, because those are actually with reference to this particular case, if I may come to those judgments. And those deal with both issues, one of competence of appeal and intra-court appeal. Both have been dealt by the 2 separate opinions. If your lordship will kindly see page...
that was without my opinion. Without my opinion.
लेकिन सर आपके सवाल की वजह से डिबेट शुरू हुई. आप सवाल नहीं पूछते.
Actually, this should have been that I should have been asked what is your opinion. Without my opinion, it was said to.
लेकिन सर आपके खिलाफ जवाब देके भी आपके हक में जवाब दे दिया, वो देखिएगा आप जरा पेज 9 पे.
चलो मैं उसका जवाब अभी जो खत्म हो गया तो उसमें दे देंगे.
Sir, page 9 of the paper. Now, these are 3 unreported orders, my lord, but I think these are such crucial orders should be. If I may first to Justice Mandokh's very interesting question, which he's been constantly raising in these proceedings. If I may come to page 9, and I'll read from the second paragraph, para 2, 5th line. The question which needs consideration is whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect of matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution. Reference is made to the order dated 13/4/2023 passed in Constitutional Petition 9 of 20. This very petition, relevant portion whereof is reproduced above. I'll leave the portion, I'll read the last 4 lines. As the issue involved is in this petition is identical to the issue involved in constitutional petition number so and so, therefore let it be placed before the Honorable. Now, on this, a dissent was done by Justice Hassan Azhar-Rizi. Very interesting opinion, my lord, page 12, if your lordship may kindly see. Now, the main thrust of this opinion is on that this question did not arise in the case. That is why the case was really decided on the merit. There's a very important paragraph on this intra-court appeal, which is at page 17, para 14. It's the same it is the same line of argument which Justice Mazhar had alluded to yesterday. Para 14, page 17. As far as the question of whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect to matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution is concerned. So both constitutional forums, intra-court appeal in the law reforms order. I am of the humble opinion that Article 175 of the Constitution by its clause 1 ordains that there shall be a Supreme Court of Pakistan and a High Court of each province, and recognizes that such other as may be established by law. Clause 2 of that article provides that no court shall have any jurisdiction save is or may be conferred on it by the Constitution or by or under any law. For the above question, it is sufficient to say that the Supreme Court of Pakistan and the High Courts have been established by the Constitution, that they have such jurisdiction as has been conferred upon them by the Constitution, that they have also such other jurisdiction as is or may be conferred upon them by or under any law. The expression law here has been used to distinguish it from Constitution, which is higher in authority and obviously means an ordinary or sub-constitutional law made in the exercise of the powers granted by the Constitution. Reference in this regard may be made to the judgment of this court in the case of Brother Steel Mills Limited versus Mia Ilyas Miraj, PLD 96 Supreme Court 543, wherein the provision of section 15 of the Code of Civil Procedure Amendment Ordinance 1980, which also provides a right of appeal to a bench of 2 or more judges of a high court from an interlocutory order made by a single judge, that court in the exercise of its original jurisdiction has been interpreted by a 5-member bench of this court. Even otherwise, no provision of the Constitution places such bar on the power of the legislature. Both under 199 and 184.3, there is no bar that a right of appeal through a statute cannot be provided. Now, your lordship may note two things about it, and I'll come back to this. The first is that legislative competence here has been placed on Article 175(2). That's the first thing. Number two is that it has been held that even if the order is from a constitutional forum, as Justice Mandokhel had pointed out, even then an intra-court appeal can be provided through an ordinary statute. Now, it's very interesting how Justice Munib deals with this, because he extends the notion of legislative competence and agrees with Justice Hassan Azhar Rizvi on the issue of the Law Reforms Ordinance, page 20.
As a referee judge.
Ji?
As a referee judge, you were.
Sorry?
Referee
Yes,
judge.
referee judge, sir. Page 20, sir. I may read. Para 3 में जरा context दे दूं. On hearing the matter, a difference of opinion arose between the learned members of the bench on a point that was, it appears, framed by Jamal Khan Mandokhel, his lordship, expressed doubt whether a right of intra-court appeal could be provided by ordinary statute, like the ordinance against a decision of a single judge of the High Court, exercising jurisdiction under Article 199. Reference was made to certain pending petition filed under Article 184(3) of this court. Now, let me come to para 4. A difference of opinion has, next page, has arisen in my view. The question of law requiring resolution is as follows. Can the appropriate legislature provide by ordinary statute for a right of appeal against a decision of a single judge of a high court exercising jurisdiction under Article 199 of the Constitution, such that Section 3 of the ordinance is a valid legislature? Now, as far as where does legislative competence come, or how is appeal in terms of legislative competence to be framed? Very interesting paragraph, para 9, page 23 of this opinion. If I may read kindly from the last line. One is a right, I move to the second page, that is relatable to a specific entry on a legislative, this is the next page, 24, or to a particular legislative
If I may request you kindly read the whole.
Should I read the whole, sir?
I think
Ji,
that
ji,
may
ji, ji.
provide
But,
some-
ji, sir, ji, sir.
Some background.
But of course, the ordinance was not just an amending statute. It also had Section 3, which provided, as presently relevant, for a right of intra-court appeal in terms as noted above. That also had to be taken into account while determining its pist and substance on the commencing date. I begin by noting entry number 46 of the concurrent list. This provided in material part the legislative competence of jurisdiction and powers of all courts except the Supreme Court with respect to any of the others in this list, all courts including the High Court. Right of appeal can, for present purposes, be divided into two categories. One is a right that is relatable to a specific entry on a legislative list or to a particular legislative competence. The other is what might be called a general right of appeal. Now, these are crucial lines. Now, it is well settled that a right of appeal is a substantive right which must be expressly conferred. However, jurisprudentially, appeals in a general sense are regarded as a part of procedural law. In my view, this categorization is relevant for purposes of legislative competence insofar as a general right of appeal is concerned. Such a general right would lie in the legislative competence relating, as the case may be, to civil or criminal procedure. This conclusion is bolstered by the fact that both entries relating to criminal and civil procedure, number 2 and number 3 respectively, included therein all matters included in respectively the Criminal Procedure Code and CPC. Thus, entry number 3 provided in material part as follows: Civil Procedure Code and all matters included in the Code of Civil Procedure on the commencing date. The two codes of course contain specific provisions by way of general rights of appeal. It may be noted that the context here is legislative competence. Therefore, what was relevant was not the type of appeal encoded in the Criminal Procedure Code and the CPC, but rather the categorization thereof in terms of their nature. Thus, a general right of appeal was included in the legislative competence conferred by these two entries of the concurrent list, my lord. So, what seems my reading is that as far as legislative competence is concerned, when you're looking at entries, then it is not a presumption that the competence to have a law on appeal would fall within a category which does not deal with procedure. It can deal with procedure. At least that is what it's saying.
Mr. Faisal, and I think that is echoed, I might not have looked at this, but I found 53 Lahore, 284, it's a DB judgment, and I just read this paragraph, which is important.
I found it very interesting, but I may be misreading.
Which actually talks about exactly something like this, which needs to be discussed, which is the letters patent appeal is not really an appeal in the strict sense. It may be more aptly described as an internal arrangement of the court for reviewing its own decision, given in the first instance by one member of the court. Then the first as well as the second decision remains the decision of the court. And if you look at Order 5, Rule 2 in the rules,
there's a chamber appeal.
There is a chamber, it doesn't say appeal, it says for reconsideration to a 3-member bench. So three judges, if you see Order 5, Rule 2. So, I mean, before going into 55, let's sort this out whether at all this could form part of having an intra-court appeal.
Rule 3, Order 5, Rule 3 says appeal. Rule 3 says an appeal shall lie from registrar in all cases to
as registrar.
From
Agla pade na?
To the judges in chambers.
That's right. And then there is from a single judge to
administrative order, and that's an administrative appeal.
But it's still an
not
appeal.
a judicial order.
It's still an appeal, and it's framed under 190.
Fair enough. I mean, it probably has a color, rightly said by my learned colleague, that it could be administrative in nature, but we need to understand the context. If you look at Order 5, Rule 2, it talks about the power of the court in relation to power.
In relation to the following matters may be exercised by a single judge.
Can you tell us where are you reading from?
Order 5, Rule 2, Order 5, sir, Supreme Court rules.
The power of the court.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of any aggrieved party by a bench of not less than 3 judges, which may include the judge who dealt with the matter.
It refers to reconsideration. We don't know where to slot it. It is probably administrative in nature also. But what I'm trying to say is that intra-court appeal under these 3 judgments that I have looked at are talking about that it is an internal setting and a procedure and arrangement and not considered to be substantive in that sense, which has been echoed elsewhere also. So whether at all it becomes part of a procedure of practice and procedure rather than as a substantive.
I think this note opens up that question. If I may just read the last paragraph and then your lordship. Sir, as far as Justice Hassan Azhar Rizvi's opinion, which basically dealt with the merits of the case and the paragraph on the intra-court level. There's a paragraph in Justice Munib's opinion on that, which is also very important. If your lordship may kindly see page 25, para 12.
Para 12.
Ji sir, page 25. In view of the above discussion, I am in no doubt that the question referred to me ought to be answered in the affirmative. It is so answered accordingly. I also agree with my learned colleague Hassan Azhar Rizvi that leave to appeal should be refused and leave petition dismissed. उससे ऊपर जो है 4 लाइनें वो है in contrast. My learned colleague Sayyid Hassan Azhar Rizvi has rightly noted in an order. See para 15. Now para 15 flows from para 14, dependent on para 14. That despite lapses of more than 50 years from the promulgation of the ordinance, no such question called the legality of the ordinance has been raised by any party lawyer, any high court or this court, my lord. And para 14 dealt with 2 things. There can be an intra-court appeal from a constitutional judicial forum, and secondly, the legislative competence based on Article 175, sub-Article 2, my lord.
See, Mr. Counsel, the thing is that you are of course referring to my order.
Yes, sir.
It is an order of the court, and therefore it is for others to make of it what they will.
Yes.
It is not for me to now read and interpret it, but I am picking up on the point that you think flows from this order.
Ji.
Seems to me, with respect, that it cannot conceivably flow from this order. The reason is that the issue before the court or before me as the referee judge was a right of appeal conferred by statute, right? And as you have read, I have noted two kinds of appeal and the jurisprudential aspect of it and the language of entry 3 of the current list and so on and so forth. However, to translate this into practice and procedure as embodied in Article 191, in my view, would, and that is certainly not what this order was about, but would be incorrect. Why? For two reasons. One, because the subject matter of practice and procedure, insofar as law is concerned, you have told us that in your view it is limited, restricted, supervisory. It is not the entire breadth of the practice and procedure of the court. So if that is so, then no law which is so restricted, which is of a supervisory law-making capacity, which is restricted, supervisory, restrictive in nature, surely can confer a right of appeal in terms of that subject matter.
I think it can.
Just one more. Yes. Secondly, and more importantly, the subject matter, practice and procedure of the court is not restricted to the legislature. It is open even to the Supreme Court.
Yes.
It is primarily for the Supreme Court. So one conclusion that would from what you are saying is that the Supreme Court can itself create a right of appeal in exercise of practice and procedure. Is this what you are arguing?
My lord,
in relation to Section 5 now, we are in context here in Section
my
5.
lord.
So tomorrow the full court amends the Supreme Court rules and creates a right of appeal. Can
My
you do
lord,
that?
my lord, I make two alternative arguments when it comes to the legislative.
Mr. Faisal, before going to answer the question of my lord, please complete that page 18, paragraph 16 of my lord Hassan Tazir. It's very interesting paragraph 16, page 18.
Para 16, sir. हाँ सर जी जी ये भी बहुत इंटरेस्टिंग है आई एम सॉरी दिस इज आल्सो क्रूशियल टू दिस मैं पेज 18 पे हूँ सर पैरा 16 it's very important that what Justice Hassan Rizvi has reminded us is very important to be reminded all the time. Paragraph 16. Surprisingly, this question, page 18, surprisingly this question has also not been raised in this case, but it has been taken up by my learned brother on his own. The process of judicial scrutiny of legislative acts on the touchstone of the Constitution is technically called judicial review. The courts, however, should adopt judicial self-restraint in discharging their functions of judicial review in order to maintain harmony between the judiciary, the legislature, and the executive. The power of judicial review of legislative acts vested in the High Court, and this court must be exercised with freedom, wisdom and self-restraint, and not in a spirit of cold war between parliament or state legislature and the courts. Non-interference with the view of the majority in parliament with regard to what is reasonable and interference with what is prohibited by the Constitution may perhaps be a harmonious path for a peaceful transition for a glorious future. In Lahore Development Authority versus Mrs. Imran Tiwana, 2015 SCMR 1739, this court, while stating the rules which must be applied to declare laws unconstitutional, has held that if a case can be decided on other or narrow grounds, the court will abstain from deciding the constitutional questions.
So, my lord,
Sir Siddiqui, on a lighter note, if I may compliment you, what apparently were apparently divergent views, you have to reconcile all of them.
sir, I try to read everything which your lordships write,
Are
whether
both
reported or unreported. Sir, now I'll come back to this, but my reading of your lordship's order is that if, for the purposes of legislative competence, appeal is a part of procedural law, if that is so, then Parliament can also confer appeal.
Not all appeals, but intra-quota.
Intra-quota. 191 read with 58, and the court can also do that.
Court can also
Yes, the court can also do that. Why is appeal not a restriction? I think an appeal against orders passed under 184(3) are not liberating, are not restrictive. They would be liberating, because it is a problem that there is no appeal against such tremendous power exercise.
This Order 5, Rule 2 that you read, even though we would certainly consider it as an administrative appeal, but practically it is an appeal provided it determines the right of the party, and the rules are providing for that appeal.
Yes. So this is one way I can, that legislative competence.
I've recorded your contention. Correct me if my understanding is correct. Intra-court appeal liberating, and both Supreme Court and Parliament can provide for them.
Yes.
Okay.
Yes.
And why
They are not always restrictive, my lord.
If I may follow what my learned colleague has said with regard to Order 5, why didn't
I can't hear you. I can't hear you. I mean, I can't hear you.
I'm so sorry. What my learned colleague said regarding Order 5, it's why do the rules use the word reconsider? Why not simply call it an appeal? Because read it. आप उसको पूरा पढ़िए ना, आप उसको kindly पढ़िए. There's a reason why it's called reconsider.
The power of the court in relation to the following matters may be exercised by a single judge sitting in chambers, but subject to reconsideration at the instance of an aggrieved party by a bench of not less than 3 judges, which may
include the judge who dealt with the matter.
Yes.
It cannot be an appeal. This is not an appeal because it cannot be an appeal.
So this is a review?
This is not a review.
Reconsideration.
This is a reconsideration.
Sir, it is like a review then.
No, it's not.
A review, practice and procedure में review का power confer कर दिया.
ये देखिए ना,
अगर
deliberately
in an appeal can't judge who passed an order sit?
Sir, that is not the notion of.
For instance, I'll just give you another example. A bench, their divergent views, right? And the matter is referred to the Chief Justice to send for opinion of the 3rd judge. Alternatively, what could happen alternatively is, because one set of arguments were, the 3rd judge hasn't heard the arguments as were asked, or that particular question as articulated was not put to them.
Yes.
So can the Chief Justice then say, can you all 3 sit together and decide it, since now the possibility of a hung court will not arise? It can still go in 3 different ways. So what is that called? I mean, that option is available to the Chief Justice. I'm adding another member on the bench and hear this matter again, or whatever you want to call it.
And if I could add to that, if you look at Section 5, you see, I mean, this is a traditional notion, but if you look at Section 5 of the law, the one under challenge, it says that the appeal would go to a larger bench. Now, I just, want to understand whether a larger bench could have this earlier set of judges along with other judges, or a new set of judges as a larger bench. So, I mean, where is this restriction inherent? I mean, traditionally, yes, appeal would be heard by, but could there not be a hybrid system where there could be an appeal to a larger bench in this particular situation, which is the apex court dealing with these matters, and that sort of resolves the problem of 4 and 5 also? Why can't 1 or 2 other judges be added to it? I mean, is there a problem somewhere, or does it?
My lord, for instance, I'll just further add to it. There have been instances where review matters have come up before larger benches, even during the subsistence of the judges who had earlier passed the order, and they are reported cases. So what is that? Is it a classical review will be heard by the same judges? That's simple enough. Now, this matter has been decided by 2 or 5 or whatever, and one judge has been removed, 3 have been added. So that judge here himself being bench is reviewing the matter, and the others are exercising powers of appeal. Surely they can't be exercising powers of review. I don't know. So these, as His Lordship, Mansoor Isha has pointed out, it may be a different category of animal.
Let me just build on what both your lordships have said. Let us forget about the distinction between appeal and review. Reconsideration.
That is only for the reconsideration, Mr. Faisal. You kindly read Rule 2, which says the reconsideration by the bench of 3 members. If you go through Rule 4, that is an application for reconsideration under Rule 2, and appeal under Rule 3. Appeal is an appeal live from the registrar in all cases to the judge in chambers.
So let us look at this word reconsideration.
Two parts of that. The reconsideration, that would not be considered an appeal, but the appeal is provided separately.
That is against
the order of the registrar in chamber.
That is
against suppose if we were to consider Section 5 and consider it as a reconsideration.
That is why the word reconsideration has been used, in which the judge who passed the order may be included in that bench.
Yes.
So it's not a part of appeal, it's not just like an appeal.
But let us
see.
If we were to just say that Section 5 is a reconsideration, and
Sir,
let's not in the word appeal.
Let's just focus on this word reconsideration. What is happening? Sir, मैं एक बात
लेकिन ये आप देखिए, ये जो रिव्यू एक्ट जो पास हुआ था इस एक्ट के बाद, उसमें लिखा गया था रिव्यू शैल बी हर्ड लाइक एन,
मैं उस पे भी आ रहा था,
एंड उसके अंदर स्पीकिंग entirely for myself,
and it was struck down on
given a concurring judgment in which I have pointed out the serious jurisprudential issues that would arise where half the bench is essentially hearing it as a, because they've heard it before as review, and half the bench is hearing it for the first time, therefore an appeal. You can't mix and match like that.
Sir, let's forget about this distinction between appeal and
review.
Let us concentrate about the word reconsideration. Single judge ने order किया है, उसको reconsider कर रहे हैं 3 judges.
But that is on the administrative side. It's not
Sir,
the judicial
उसमें
order.
applications decide हो रही हैं. अब reconsideration has become, which is in the nature of a review.
All those matters in Order 5, even though, well, it passes for whatever we may call it as administrative, but the substantive rights being decided.
And they have been made a part of a law which is limited to practice and procedure.
But
so the word reconsideration.
Is it on administrative side, Mr. Faisal, or the judicial side?
Yes, sir.
Is this on the administrative side or the judicial side?
This is on the administrative side, sir.
Then why the word use aggrieved party by a bench of not less than 3 members? The bench is constituted.
Yeah, I don't know if this
judicial side or the administrative side.
Taking that point further, I mean, whether at all these straight jackets about this administrative moving into judicial.
Probably the bard said it best. A rose by name would smell just as sweet.
I would say,
so whatever you call it.
I would say reconsideration and order of your brother judge on judicial applications, if that can be considered as a part of procedure and practice, my lord, then just building on what Justice Munib has said in his opinion, why not appeals as a part of procedural law? So, but that's my alternative. But let me come to my main argument, which is legislative competence as far as appeals are concerned. I rely on entry 55. And like Hassan Azhar Saab's judgment, where he relies on 175(2), the judgment authored by her ladyship Aisha Malik Saiba has also relied on 175(2), read with entry 55 in the CCP judgment, which conferred an appeal to the Supreme Court.
So, see, as pointed out yesterday, there is a difference between bringing an appeal to the Supreme Court as opposed to creating an appeal against an order of the Supreme Court. So when you are relying on examples where the appeal is coming to the Supreme Court, it's different. The whole the way of looking at the law and interpreting the law will be different. The question here is not about can this appeal come to the Supreme Court, it's about whether this appeal under 143 amounts to a creation of jurisdiction or whether it is the enlargement of the jurisdiction. I don't see how any of the issues that you are presenting have answered that particular question.
These are two separate
Mr.
questions.
Faisal, I mean, if the appeal comes through a statute, or if the appeal comes through a statute like the Competition Act or the Elections Act or whatever, they are enlarging the jurisdiction of the Supreme Court.
That is
Either way, it goes directly into Entry 55.
One of the questions which was raised by Justice Ijaz was that if you create a new appeal, is this enlargement, or this is, because enlargement would imply something being there that is being enlarged. But your ladyship's judgment includes within the term enlargement in para 62 of the CCP judgment 2021 CLD, that enlargement in creation of a new
Can you give me the citation too?
Sir, this is 2021 CLD 214 at para 62-64. But let me come back.
Para 62
to 64. But let me come to, there are two parts to the objection which have been raised. The first part is, where does legislative competence come from? Which end do you rely on? The second part is the problem which your ladyship has raised, which is, what is the constitutional procedure to be adopted to confer this appeal, whether it's through an ordinary statute or through a constitutional amendment. Let me deal with both objections separately. Let me first come to the objection of legislative entry and legislative competence. If I may draw your lordship and ladyship's attention to entry 50, kindly, it's quite a complicated entry. मैं अगर इसको जरा ब्रेक डाउन करके पढ़ लूं,
अगर आप पढ़ते हुए ये एंट्री 55 को एक दफा दोबारा से पढ़ें,
वही मैं पढ़ रहा हूं सर,
आप उसमें you miss out on the jurisdiction powers of all courts. What do you mean? What is excluded then? अगर हम आपकी बात माने तो फिर तो आप, क्योंकि उसका जिक्र कॉन्स्टिट्यूशन में हुआ है, तो आप उसकी हर चीज को इनलार्ज कर सकते हैं। वो आप बताएं, आप क्या समझते हैं इसके?
और दूसरा, इसमें इसी सवाल में अगर पढ़ते हुए टू सच एक्सटेंट एज एक्सप्रेसली ऑथराइज, जी, इसके ये ऊपर के साथ पढ़ना है, नीचे के साथ पढ़ना है, कहाँ पढ़ना है?
Let us read this entry. Jurisdiction and powers of all courts except the Supreme Court. Now let me stop here. Your lordship, ladyship, may just keep your eye on the word jurisdiction and power, because it will occur again, but in a different form. With respect to any of the matters in this list. Now, this of course is not relevant, only to the extent that enlargement of jurisdiction and supplementary powers have to be understood by the first part. So it's a different thing which is being talked about in the second part when one is talking about the Supreme. Now,
और अंडर से पढ़े ना, और अंडर.
जी जी. And to such extent as expressly authorized by or under the Constitution. So this is the first condition, that if you want to legislate under this entry, then you need a conferment by or under the Constitution.
So is it your argument that this by or under would bring in item 58?
No, this is okay. Not. But there are two restrictions on this entry. It is not an open-ended entry.
So you're saying that this, to such extent as expressly authorized, is to be read on the first part of the entry relating to the high courts and other courts, or to the Supreme Court?
No, second
or
part.
Both?
Second part.
Second part.
Yes.
Okay.
To the Supreme Court part.
Okay.
To such extent as is expressly authorized by or under the Constitution. Now you need to seek this conferment of power from other provisions of the Constitution, either expressed by or necessary implication. But that power,
55 में Mr. Faisal, ये जो दो लाइनें हैं ना, with respect to of the matters in the list, ये तो हो गया बाकी कोर्ट्स के लिए.
ये तो कोर्ट्स के लिए हो गया. ये हमारे लिए
से शुरू हुआ, वो फिर आगे सुप्रीम कोर्ट का तस्करा.
जी. अब सुप्रीम कोर्ट.
हाँ चल, इसके मानी पे एक्सटेंट के.
और इसमें जो express authorization, the words used are expressly authorized by the Constitution. Where do you get the express authorization from?
Yes, but it is by or under. That is critical.
No. You see, express means express.
No.
It can't be implied. When it says express, then it has to be express.
I'll
You
explain.
can't read implied
Let me just
into it.
explain the other two restrictions and then I'll come back to this.
I am really enjoying your physical motions. It makes me a little dizzy, but I'm really
Sir, I'm
refreshing
sorry,
also.
sir. I'm sorry.
No, it's okay. I mean, it's just on the lighter side.
If you stop him, you won't be able to argue.
No. I just find it very refreshing.
Article 2 is the only exercise I get, sir. Sir, the first restriction is the enlargement of the jurisdiction of the Supreme Court. Now, your Lordship will see the difference between the first part and the second part. You can't legislate in relation to all matters in any way when it comes to the Supreme Court. It must be, there is a restriction involved. You have to justify the law as enlarging the jurisdiction of the Supreme Court.
But expressly authorized.
Yes.
वो बताएं वो कहाँ है?
उसका क्या मानी है?
एक मिनट, second part पढ़ लूं जी. And the conferring thereon supplementary powers. So it's not that you can legislate on any powers of relating to the Supreme Court. It should be a law that confers powers on the Supreme Court, supplementary.
In addition to what is already mentioned.
Ji?
In addition to what is already there.
Yes. So this is a way to protect the jurisdiction and the powers of the Supreme Court. That if the
Power दोनों है
Parliament
ना, एक तो enlargement का भी है.
निगरान वज़ीर-ए-आज़म अनवारुल हक काकड़ एक रोज़ा दौरे पर कोयटा पहुंच गए। वज़ीर-ए-आज़म सूबा बलूचिस्तान में नेशनल एक्शन प्लान के निफाज की मौजूदा सूरत हाल के हवाले से मुनक्किद होने वाले बलूचिस्तान एपेक्स कमेटी के 14वें इजलास में खुसूसी शिरकत करेंगे। बलूचिस्तान की निगरान सूबाई क़यादत से मुलाकात भी करेंगे। बलूचिस्तान की क़यादत के साथ तामीरी बातचीत का मुंतज़िर हूँ। निगरान वज़ीर-ए-आज़म अनवारुल हक काकड़। निगरान वज़ीर-ए-आज़म अनवारुल हक काकड़ से निगरान वज़ीर-ए-आला बलूचिस्तान सरदार अली मर्दान खान डोमकी की मुलाकात। नेशनल एक्शन प्लान के निफाज के लिए मुनक्किद होने वाले एपेक्स कमेटी के 14वें इजलास से मुतल्लिक ब्रीफिंग। सूबे में अमन व अमान की मौजूदा सूरत हाल पर गुफ्तगू। मुलाकात में निगरान वज़ीर दाखिला मीर सरफराज अहमद बुगटी भी मौजूद। डॉलर की कदर में गिरावट का सिलसिला जारी। इंटरबैंक में डॉलर मजीद ₹1.16 सस्ता हो गया। इंटरबैंक में डॉलर ₹280 और 49 पैसे पर पहुंच गया। गुज़िश्ता रोज इंटरबैंक में डॉलर ₹281 और 65 पैसे पर बंद हुआ था। स्टॉक मार्केट में भी तेजी का रुझान। 100 इंडेक्स में 300 से ज़ायद पॉइंट्स का इजाफा। दौरान ट्रेडिंग 100 इंडेक्स 48,000 की नफसियाती हद उबूर कर गया। सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों की समाअत जारी। चीफ जस्टिस काजी फाइज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। फैसला आज ही मुतवक्के। चेयरमैन पीटीआई को पार्टी चेयरमैनशिप से हटाने का मामला। पीटीआई में ममनुआ जराए से फंडिंग लेने पर इंतखाबी निशान वापस लिया जाए। दरखास्त गुजार का मौक़िफ़। अगर आपको लगता है कि पीटीआई में अब भी फॉरेन फंडिंग हो रही है तो हमें सबूत दें। कोई चीज सामने आएगी तो हम कार्रवाई करेंगे। चीफ इलेक्शन कमिश्नर। समाअत 3 हफ्ते के लिए मुलतवी। सदाकत अब्बासी का चेयरमैन पीटीआई के खिलाफ बयान हल्फी। 4 मई को पीटीआई इजलास में 6 मई की रैली का मकाम कचहरी से मरीर चौक तजवीज़ किया। चेयरमैन पीटीआई ने कहा कि कचहरी चौक का फासला
which makes it very, very pleasant out there. We've got the toss representative and the Pycroft is the match referee. Dasan Shanaka, the Sri Lanka's captain, and Babar Azam here representing Pakistan. Heads.
It's a hit.
We are going to bet. Dasan Shanaka has won the toss. Dasan, what are you going to do and why?
We're going to bet first. Since we saw some for the turn last couple of games in the later part of the games, yeah, we are happy to bet first.
I just want to revisit that last game. You've put the spotlight on yourself with your form. How pleasing is it for you to get some runs in that last game?
Yeah, it was so pleasing because I worked hard for that, but still, you know, it's a matter of time to get into the form, so I'm really happy to get going in this tournament.
Any changes to your lineup today?
We got one change. Mahesh Tikshana comes in for Kasun Rajitha.
How do you, I suppose, get more out of your bowling group given what happened in Delhi?
Yeah, see, we started really well, but it's about the control and the execution. So I think we had a couple of practice sessions, and the boys have been playing a lot of cricket. So yeah, in this game, hopefully we'll do the right things in this game.
What are those right things to sort of improve that record in World Cups against Pakistan? What's key?
See, hitting the right areas and the getting Yorkers and the variations right. So probably it might help us to get over.
All the best to you, Dasan, and your
Thank
team.
you.
Baba, how do you feel about bowling first?
Bismillahirrahmanirrahim. We are also bowling first. Pitch look like very dry and very good. So we will try to first 10 overs very crucial for us for take early wickets and put pressure in.
You've played here before. How much of an advantage is that?
Advantage is yes, we are here like 1.5 week, so we know the conditions and we know the outfield. So yeah, we will utilize that also, and that thing is for us.
Just a little discussion on the opening partnership, which hasn't gone that well. What have you done? What have you talked about?
Yes, we have not up to the mark, but today we have a one change. Abdullah Shafiq came in for a fucker. So today I hope, inshallah, they're good in this match.
Right, you say that's the one change, and that record against Sri Lanka must give you great confidence.
Yes, we have a confidence last match, and yes, we have against Sri Lanka, we have a good record. So we will try to best in this match, and looking forward to it.
All the best to you, Baba.
Yes, thank you.
A big thanks to both captains. It really is nice and cool here. Just a reminder, Sri Lanka have won the toss. They'll be batting first.
पाकिस्तान में मुकाबला श्रीलंका। पाकिस्तान टॉस हार गया, जबकि श्रीलंका की जानिब से टॉस जीतकर श्रीलंका ने बैटिंग का फैसला किया है। क्रिकेट वर्ल्ड कप का ये छठा दिन है पाकिस्तान पर मुकाबला श्रीलंका, और पाकिस्तान अपना दूसरा मैच आज हैदराबाद में खेल रहा है। आज अहम खबरें आप मुलाहिजा कर रहे थे। सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट की समाअत इस वक्त जारी है। आपको बराह रास्त ले चलते हैं।
142 where the parliament has the power to make laws. Once laws are made by the parliament, then no court shall have the.
But those laws have to be related to an entry of the legislative.
And 191 comes into field and entry.
With all due respect, your argument is circular. You see, because you start with entry 55, you go to 175.2, and then you bounce back into 175. Sorry, entry 55.
Maybe it's a ping pong day for you.
Yes. The law. Oh, we are back to ping pong.
It's a ping pong day for
If I may explain, because
the law over there has to surely mean validly enacted law.
Yes.
And for law to be validly enacted, one cannot look at Article 175(2). One has to look elsewhere in the Constitution. And wherever that may be, a legislative entry, 191, 188, what have you. All of that is the premise of 172. It can't, 175(2) does not of its own. I mean, that's how I understand it. Maybe.
My lord, let me just read a passage from a judgment which explains my argument, and then I'll further explain.
Faisal, I'll just read this sub-article 2 again. No court shall have any jurisdiction save by or under any law. Now, it's speaking for myself, it's very, very clear that by and under the law, jurisdiction can even be conferred on this court because it relates to all the courts. Now, the only restriction is in entry 55.
Yes.
It can be enlarged. Yes. No jurisdiction conferred under the Constitution can be curtailed or in any way interfered with by or under the law.
Yes. Let me just explain.
Mr. Faisal, you haven't explained the entry. Yes, please, could you just take a little time to just explain to such extent as expressly authorized. So where is it expressly authorized in the Constitution? Where is it under the Constitution expressly authorized that you could enlarge the jurisdiction under 184?
May I explain that by reading a passage and then I'll state my argument. 2021.
So I take it that you agree with us that 175(2) does not confer jurisdiction
It
or
does.
competence.
No, it does.
Competence.
It does. It does.
Okay, you insist that it does
No,
confer
I don't.
competence even if it is couched in negative terms.
I think negative is a relative word.
And
if
it
it
says no court, what else could be a negative?
And since law can here mean provincial law, it likewise confers it on provincial law. So what is then to prevent a province from saying, we are conferring a right of appeal on the Supreme Court relying on this 175(2)?
Because
here is our law, we are conferring a jurisdiction.
Because they would be barred under entry 55.
That's the whole point.
Yes.
That therefore validly enacted law.
Let me explain this. If I may read a passage. Exactly the same problem came before the court. 2021 CLD 214, para 63. Both these provisions are dealt with.
Section 44 of the Competition Act के अंदर अपील है against the
तो
appellate
फिर उसमें
tribunal.
यही सवाल आ गया ना कि
मैं उस पे आता हूँ प्रोसीजर
नहीं, ये जो कॉम्पिटिशन एक्ट ने अपील प्रोवाइड कर दी, जो सवाल ये है कि वेयर इज इट मेंशन्ड एक्सप्रेसली
जरा देखिएगा इसी में जवाब
कॉन्स्टिट्यूशन फॉर
अगर आप देखिएगा इसी में जवाब
175(2) के तहत ही लार्ज हुई होगी।
जी अगर आप देखिएगा पैरा 62 it's the exact problem which her ladyship Justice Aisha Malik has dealt with. Exactly the same.
Para 62 is in
62.
Which page?
293.
293. Thank you.
सर पैरा 62 में मैं पहला पैराग्राफ नहीं पढ़ूंगा, अगर आप देखिएगा एंट्री 55 रिप्रोड्यूस्ड है, ठीक, उसके नीचे मैं पढ़ रहा हूं. There are two parts to entry 55. Have your lordships found?
Yes.
There are two parts to entry 55. The first part allows Parliament to legislate on the jurisdiction and powers of all court in respect to matters in the FLL, which is the Federal Legislative List. The Supreme Court has been excluded from this part, meaning that Parliament cannot legislate on the jurisdiction and power of the Supreme Court in so far as the entries in the FLL. The second part of entry 55 deals with the enlargement of the jurisdiction of the Supreme Court of Pakistan and confirming of supplemental, confer supplemental powers as well. Article 175(2) of the Constitution states that no court shall have jurisdiction save as is conferred on it by the Constitution or by or under the law. Article 175(2) of the Constitution gives Parliament competence to confer jurisdiction on the court by or under a law. The question is does this include the jurisdiction of the Supreme Court? When Article 175(2) is read with entry 55 of the first part of the FLL and Article 142 of the Constitution, Parliament is competent to make law enlarging the jurisdiction of the Supreme Court and conferring supplementary power, which is provided by the Constitution. By or under the Constitution, meaning that the constitutional jurisdiction of the Supreme Court of Pakistan cannot be taken away, but where the Constitution authorizes on jurisdiction, it can be enlarged. So these are the two
question again is
judgment, has it been assailed before this court?
Yes.
क्या हुआ उसका?
No, it's not suspended. I think leave grant हुई.
इसे निकालिए, ये आप तो चेक कीजिए, ये इसके नंबर ले लीजिएगा, बता दें.
सर मैं भी CCP को उसमें लीव ग्रांट हुई है, सस्पेंड नहीं.
Is it unanimous or is it a unanimous judgment?
Sir, on certain issues,
on this issue,
on this issue, all three agree. All three agree. Okay. On this issue, which is given at the last para of her ladyship's judgment, अगर आप वो भी देख लें, उन्होंने बताया किस पे डिस्प्यूट है, किस पे नहीं है.
But Mr. Faisal, my problem with perhaps this judgment also, or otherwise, is that how do you pass this, the test of expressly authorized by or under the Constitution? So what I would understand from this is that somewhere in the Constitution it must expressly talk about enlargement of the jurisdiction.
Not the enlargement. Not the enlargement. Enlargement and supplemental are restrictions Apart from that, you cannot. But enlargement of the jurisdiction and supplemental powers is the restriction imposed on Parliament's powers when it legislates on the jurisdiction and powers of the Supreme.
Let me
just finish with this judgment. Can you tell us the background of this judgment? What had happened?
Sir, जो Competition Act है उसकी वायरीज challenge हुई थी, and one of the provisions which was challenged was that how can a direct appeal be provided from a statutory body through a statute? That was one of the questions.
Sorry, come again.
Sir, how can a direct appeal be provided to the Supreme Court through an ordinary statute?
It was to the Supreme Court.
Yes. And what is the legislative?
Against?
Sir, Section 44 Competition Act.
Against whose order?
Sir, वो order होता है Competition Appellate Tribunal
के order के.
So, in the nature of a service type matter, direct to the Supreme Court.
Direct to the Supreme Court. Election Act में भी है. But the question which was answered was one of legislative competence. कि कहाँ से power आता है?
इसमें तो अगर आप देखें सिद्दीकी साहब, आर्टिकल 185 में 185 में सिर्फ अगेंस्ट
चाहे वो स्टेट ऑफ इजराइल है, चाहे वो इंडियन फोर्सेस हैं, और खुल के हमें सपोर्ट करना चाहिए हक और सच का, और अमन का रास्ता निकालना चाहिए। और अमन का रास्ता तभी निकल सकता है जब उनको उनका राइट जो है ज़ायनिस्ट के खिलाफ, मैं किसी भी मज़हब को एक्सट्रीमिज़म से नहीं नथी कर सकती, हर मज़हब अमन सिखाता है, मगर मज़हब की बेसिस पे जिस तरह मुस्लिम पैलेस्टीनियंस को जिस तरीके से उनको एक्सटर्मिनेट किया जा रहा है, उनको एक्सिक्यूट किया जा रहा है, उनको मर्डर किया जा रहा है, उनका जेनोसाइड किया जा रहा है, वॉर क्राइम्स किए जा रहे हैं, ये वॉर फुटिंग पे इस काम को रोकना पड़ेगा। अगर ग्लोबल पावर्स इस वक्त नहीं सामने आएंगी इन एक्शंस को, और जिस तरह की ओपन थ्रेट्स इजराइल दे रहा है और वहाँ पे मस्जिदों को शहीद कर रहा है, कुरान पाक की बेहुरमती की जा रही है, जिस तरह इंसानियत दफन की जा रही है, जब तक इसको रोका नहीं जाएगा और इसको टेबल पे रिजॉल्व नहीं किया जाएगा, और पैलेस्टीनियंस की अपनी ज़मीन है, गाज़ा उनकी अपनी ज़मीन है जिसके ऊपर कब्ज़ा किया इजराइल ने, वो ऑक्यूपायर्स थे, और फिर उसके बाद जब उन्होंने रेजिस्टेंस फोर्सेस ने जब रीऑक्यूपाई कर दिया है गाज़ा को वहाँ पे, और अब उनको कहा जा रहा है कि हम यहाँ पे कारपेट बॉम्बिंग करेंगे, इजराइल नेतन्याहू कह रहा है, और यहाँ पे हम लोग रबल्स में तब्दील कर देंगे। तो जिस खौफनाक सूरत हाल पे ये जा रहा है, ये वही है जो मोदी कर रहा है मकबूजा जम्मू कश्मीर के अंदर। तो वर्स्ट ह्यूमन राइट्स की जो बारबैरिज्म, जो ब्रूटैलिटी और जो ऑपरेशन हो रही है, वो दुनिया के अंदर ये दो सबसे ऑप्रेस्ड नेशंस हैं, और जहाँ पे कोई इंसान होना ही सबसे बड़ी सजा है। तो इनके भी जो प्रिजनर्स हैं, जो इनके साथ वॉर क्राइम्स जो किए जा रहे हैं, इसके ऊपर मैं बहुत सीरियस, क्योंकि ये तो मेरी अपनी ज़ात का है, जिस तरह हम कश्मीर की आज़ादी की तहरीक लीड कर रहे हैं, उस तरह पैलेस्टीनियंस की प्रॉब्लम्स को हम समझ सकते हैं, और इसके लिए भी कुछ लाए अमल मैं अपनी तरफ से प्राइम मिनिस्टर को भी तजवीज़ करूँगी, और अपनी पर्सनल कैपेसिटी में भी जो है इंटरफेथ हारमनी की इस वक्त बहुत ज़रूरत है। इंटरफेथ हारमनी और पीस एक्टिविस्ट की डेलीगेशन जाएं, चाहे वो इजिप्ट जाएं जहां वो ज़ख्मी सारे वहां पर आए हुए हैं, चाहे गाज़ा में किसी तरीके से सेफ एंट्री कराई जाए, वहां पे लोगों को फर्स्ट एड प्रोवाइड की जाए, उनको एयर ड्रॉपिंग ऑफ फूड सप्लाईज कराई जाए। वहाँ पे बिल्कुल ही लाइट सारी बंद है, वहाँ पे एक अंधेरा है, वहाँ पे जिस तरीके से डबल्स में तब्दील किया जा रहा है, वहाँ पे डिमोलिश की जा रही है उनके घर, उनकी बिल्डिंग्स, उन लोगों को जिस तरह टारगेट किया जा रहा है। और ये 21st सेंचुरी है, इतना खौफ आता है जो कुछ वहाँ पे हो रहा है इस वक्त। तो इसलिए इसके ऊपर मैं जितने भी दुनिया भर में मैं अपील करती हूँ ह्यूमन राइट्स के जो एक्टिविस्ट हैं, जो पीस के एक्टिविस्ट हैं, कि खुदाया हम लोग पीस के लिए अपने हाथ से हाथ मिला के हम लोग निकलें और अमन के रास्ते पे निकलें, अमन की शमा आए और पैलेस्टीनियंस की आवाज़ बने। वो हक और सच पर हैं, और दुनिया ने पिछले 76 ईयर से सबसे पुराना मसला कश्मीर और पैलेस्टाइन का यूनाइटेड नेशंस के एजेंडा में।
ये बताएं कि आपने अडियाला जेल का भी विजिट किया, एक ख़ास जमात जो तहरीक इंसाफ है उसकी जानब से ये इल्ज़ाम लगाया जा रहा है कि हमारी जो ख़वातीन हैं जेलों में, खुसूसन अडियाला जेल में 2-3 ख़वातीन खुद भी आई, उन्होंने भी ये इल्ज़ाम लगाया कि हमारे साथ जो इंसानी हकूक़ की खिलाफ वर्जियाँ की जा रही हैं। तो इस पर आप क्या कहती हैं, क्या जिलों में ऐसा वाकई हो रहा है तहरीक इंसाफ की ख़वातीन?
देखें, किसी भी किस्म के प्रिजनर्स हों, चाहे वो पॉलिटिकल प्रिजनर्स हों, चाहे वो नॉन पॉलिटिकल प्रिजनर्स हों, फंडामेंटल जो राइट्स हैं बेसिक, हर प्रिजनर मेरे लिए इक्वल है। बेसिक मेरी कंसर्न ह्यूमन राइट्स मिनिस्ट्री की और मेरी अपनी जो पूरी जद्दोजहद है इंसानियत के लिए और कश्मीर कॉज के हवाले से, तो वो यही है कि जो भी प्रिजनर्स हैं उनको अच्छी हेल्थ फैसिलिटीज़ मिली वहाँ पे, उनको वहाँ पे जो है एक हाइजीन एनवायरनमेंट हो, फैमिली से मिलने की उनको इजाज़त हो, उनको लीगल काउंसिल एक्सेस हो, उनको फिज़िकली प्रोड्यूस किया जाए। और जो जहाँ तक उनके कोर्ट की बात है, वो अदालत का मामला है, वो सब जुडिस मामले हैं, उसके अंदर क्योंकि हम सब पढ़े लिखे हैं और उसके अंदर कोई भी इंटरफेयर करे तो वो आई थिंक वो बहुत ही अनसिविलाइज्ड हो जाता है। और आई थिंक वी शुड नॉट पुट प्रेशर ऑन द जुडिशरी, जो भी जुडिशल हमारा सिस्टम है वी शुड रिस्पेक्ट इट। मगर जहाँ तक प्रिजन्स की बात है, मैं खुद उनके दौरे कर रही हूँ और अडियाला जेल के अंदर भी जो मुझे वहाँ से मैंने खुद भी रिपोर्ट्स ली हैं कि प्रिजनर्स जितने भी, चाहे उसमें सियासी हैं, गैर सियासी हैं या जो भी उनके केसेस हैं, कि उनको फैमिली से मिलने की इजाज़त दी जा रही है और उनको कोर्ट्स में भी प्रोड्यूस किया जा रहा है और उनको उनके जो लॉयर्स हैं वो भी उनको मिल रहे हैं। यहाँ पे भी जाके मैं ये सारी चीज़ें चेक करूँगी और सामान भी लेकर हम जो भी यहाँ पे जो भी बच्चे हैं, स्पेशली मुझे सबसे ज़्यादा जो पेन होती है छोटे छोटे बच्चों को प्रिजन्स में देखना और ख़ास तौर पे वो बच्चे जिनकी माएँ यहाँ पे अरेस्टेड हैं और वो कहीं और जा नहीं सकते, तो उनका क्या कसूर है। तो उनकी भी काउंसलिंग हो, काउंसलिंग सेशंस भी हम अरेंज करवाने लगे हैं और उनकी भी थेरेपी हो और यहाँ पे उनको एक हेल्दी इन्वायरमेंट, प्लेग्राउंड हो, अच्छा स्कूल हो, वो बच्चे जाएँ और एटलीस्ट उनका ये जो बचपन है ये ना खो जाए कि उन्होंने आँख ही जेल में खोली, उनका ना गुनाह ना कसूर।
अच्छा मैडम, ये बता दीजिएगा, आपने अडियाला जेल का विजिट किया है, वहाँ पर जो पॉलिटिकल कैदी हैं उनसे आपकी मुलाकात हुई, खुसूसन जो एक जमात के सरबराह वहाँ पे कैद हैं, उस हवाले से हम आपसे पूछना चाह रहे हैं, उनसे आपकी मुलाकात हुई?
देखिए मैं लास्ट टाइम जब गई थी तो जिनकी आप जिक्र करें वो नहीं थे, मैं सबको मिली हूँ और मैं यकीन करें मेरे लिए सारे प्रिजनर्स, कोई रेडी वाला है, किसी ने छोटी सी चोरी की है, कोई बड़ी चोरी की है, कोई वैसे अपने आप को बेगुनाह कह रहा है या बेगुनाह है या नहीं है या कुछ भी है, मेरे लिए सारे इक्वल हैं क्योंकि जो मैंडेट मुझे मिला है मुझे वो 22 करोड़ अवाम का मिला है और उसके अंदर जो भी हैं आप सब इक्वली रिस्पेक्टेबल हैं, चाहे वो बूढ़े हैं, बुजुर्ग हैं, बच्चे हैं, मर्द हैं, औरतें हैं। और क्योंकि मेरा कंपैरिजन मकबूजा जम्मू कश्मीर की मैंने जेलों में आंख खोली है, हम लोगों ने देखा है वहाँ की बर्बरियत, तो उससे ज़मीन आसमान का फ़र्क है यहाँ पे। क्योंकि जब आपका पॉलिटिकल प्रिजनर्स पाकिस्तान के, उनको फिजिकली प्रोड्यूस किया जा रहा है, उनकी फैमिलीज उनसे मिल रही हैं, उनको लॉयर्स की एक्सेस है, आगे जज जानता है, जज ने फैसला करना है, उसमें तो कोई प्रेशराइज नहीं कर सकता, मगर उनको वो सारी ड्यू जो फैसिलिटीज़ जो लीगल हैं जिनीवा कन्वेंशंस के मुताबिक राइट्स ऑफ प्रिजनर्स वो उनको जो मिल रही हैं, जिनको नहीं मिल रही हैं उस पर हमने काम करना है। बहुत शुक्रिया।
इंसानी हकूक़ के लिए वज़ीर-ए-आज़म की मुशीर मिशाल मलिक मीडिया के नुमाइंदों से गुफ्तगू कर रही थी। उन्होंने कहा कि इसराइल में जंगी जराइम किए जा रहे हैं, इसराइल जंगी जराइम का मुर्तकिब हो रहा है और फ़लस्तीन में इंसानी हकूक़ की सरीहन खिलाफ वर्जी की जा रही है, फ़लस्तीनियों की नस्ल कुशी की जा रही है। नाज़रीन, सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों की समाअत जारी है।
There is a bar in the constitution itself that no appeal can be provided. For example,
I'm not talking restriction, enlargement. You want to enlarge it.
Let's take the example of the law reforms ordinance. Now, Article 199, as His Lordship Justice Mandokhel pointed out, it's a constitutional judicial forum. Now, the appeal under that is provided under a statute.
You see,
if you're
Mr. Siddiqui, law reforms ordinance is a totally different species. It was a continuation of letters patent. It was a continuation of other provisions, and plus, subsequently, it was saved under Article 270. So, I mean, there are no parallels. I mean, you are comparing apples with oranges.
Sir, I'm comparing apples with apples, and I'll explain
Certainly, you're trying to do, but as far as I'm concerned, I'm so far.
You compare Granny Smiths with Granny Smiths.
But the question, you know, again, I mean, reflecting, adding to
I'll come to the second part also.
You see, here you're creating a jurisdiction for the reason that the appellate jurisdiction is provided in 185. Fine. Now, 185 does not either talk of, it neither talks of an intra-court appeal, nor it talks of any other appeal envisaging something happening within the Supreme Court. What you're doing is, you're creating a new jurisdiction.
Yes.
You're creating,
yes.
You're not enlarging. And when there is a creation, then the creation can't be done under item 55.
Enlargement of
and it cannot be done in exercise of powers under either 175(2) because that is also restrictive, and Article 191, that is also restrictive. So there are restrictions all over the place, and intentionally so. So that if an appeal be provided where the lawmaker or the framers of the constitution consciously, deliberately did not provide one, then the matter should go back to them, and under the new circumstances, if they consider it appropriate, they can amend the constitution and specifically provide an appeal. Using supplemental powers, using ancillary powers, I mean, that is, I think, stretching the constitution much what it is originally
my response to
designed
the latter questions is, there is no bar under Article 199. There is no bar under Article 185. There is no bar under Article 184(3) that you can't provide an intra-court appeal through an ordinary statute. There is no bar.
Mr. Faisal Siddiqui,
Where is the bar?
Where the language used is express authorization, that is the bar. But you have to have express authorization within the constitution in order to utilize
What more
the
express
powers
bar is
available.
required than Article 175(2)?
175(2) does not confer
Mr. Faisal
legislative
Siddiqui,
competence.
if I may add to what my learned colleague is saying, see, it seems to me that the proper context of this sentence from this judgment at page 293 that you are so strongly relying upon, and with great respect, I think you are taking it out of context. But anyway, I think that is perhaps expanded upon at page 295.
सर पैरा अगर बता दीजिएगा
पेज 295 वो पैरा 63 इसमें जो अंडरलाइन पोर्शन है ना वो जरा देखें इसमें एक जजमेंट सुप्रीम कोर्ट की रेफर्ड टू है और उसके बाद उसका आई डोंट नो वेदर इट्स कोटिंग फ्रॉम इट्स कोटिंग फ्रॉम अ जजमेंट वो उसमें देखिए जिसको पैरा अंडरलाइन किया हुआ है जो
जी वो 2000 SCMR जो कोर्ट की
उसके अंदर शायद दैट एक्सपोर्ट्स दैट 175(2) पॉइंट इन प्रॉपर कॉन्टेक्स्ट पढ़िए तो सही सुखानी पढ़िए ये जो अंडरलाइंड है ना
अंडर एंट्री 55
अंडर एंट्री 55 ऑफ द फेडरल लिस्ट
सॉरी आई एक्चुअली हैव द
पेज 295 जहां
अगर आप पैरा काइंडली अगर बता दें
पैरा 63 का सेकंड पैरा 63 सेकंड कॉलम थर्ड पैराग्राफ
if the entry 55
if entry 55 was not there in the FLL, it could be argued that Article 175(2) of the Constitution in respect of matters relating to cooperative societies exclusively failing under the competence of the provincial legislature, a law can validly be made by the provincial legislature, enlarging jurisdiction of the Supreme Court and conferring on its supplementary powers. But Article 175(2) is not to be interpreted in isolation. It has to be read and interpreted along with Article 142A and the entries in the legislative list. Under entry 55 of the federal list, federal legislature is competent to make laws regarding jurisdiction and powers of all courts except Supreme Court with respect to any of the matters in such list. The other part of the entries makes the federal legislature competent to make laws enlargement of the Supreme Court and conferring thereon the supplementary powers with the proviso that this is to ascend is expressly authorized or under the Constitution. Powers and jurisdiction conferred on the Supreme Court by the Constitution can neither be inferred with or varied or taken away by legislature. However, jurisdiction of the Supreme Court can be enlarged and supplementary powers can be conferred on the Supreme Court by law in view of Article 175(2) of the Constitution, and entry 55 read with Article 142A of the Constitution leaves no doubt that such enlargement of the jurisdiction and conferment of supplementary power can only be done through law made by federal.
So this is the point, I think. This explains the context of what that sentence says, because what this passage is telling us is that the jurisdiction of the Supreme Court can be enlarged. 175(2) does not do that, but for that there must be validly enacted law, for which you have to look not to 175(2) but to entry 55 read with the Article 142A. So this is the context
142A says you look at the entry.
That's what I'm saying.
Yes.
The two have to be read together.
Yes.
But what this passage makes clear is
Yes.
that 175.2 is not a standalone power jurisdiction, because at the beginning of this para, the Supreme Court gives the example, if that were so, which is what I also put to you, then law could include provincial law, and therefore a province could say, well,
we enlarge the jurisdiction of the Supreme Court. Supreme Court is saying, no, that is not correct. That 175.2 is not independent. All that it tells us is, yes, jurisdiction can be conferred on any court, including the Supreme Court by law, but that law has to be 55 and 142.
142A. There is no other third provision which is cited for the Competition Act.
लेकिन आप जो कह रहे हैं ना, आप जो उस जुमले को जो पढ़ रहे हैं at page 293 पे, as though that is intending to give a standalone competence in terms of 152. I don't think that's correct.
Mr. Faisal Siddiqui, if I go along with that, actually, so, therefore, I don't understand how Competition Commission can confer a jurisdiction on the Supreme Court.
It's a big problem.
Unless it cannot, because it has to be, we have to pass through the same test as we have to pass today, that is expressly authorized or by or under the Constitution. So if 175 is out, then where is that expressed for, even for competition, election, or the other four different statutes?
There is also a law, Faisal Siddiqui Sahab, there is also a law, Newspaper Employees Condition of Service Act 1973, in which also the appeal is provided direct to the Supreme Court. There is no appeal in the High Court, but it is against the conviction awarded by the Implementation Tribunal. So this is also direct appeal under section 13A of the Newspaper Employees Condition of Service Act 1973. So competition, newspaper employees, contempt of court, there are three laws at least.
Since nobody has given us the background, does the Competition Commission has given authority to the Supreme Court or the Act?
No, the Act. There is a provision, section 44.
And the argument from the other side is, since it is a provincial act, it cannot confer such jurisdiction. Is this the argument?
सर मैं हाई कोर्ट में नहीं था इसलिए मैं ज़्यादा एनालिसिस
लिखा क्या जजमेंट में उसे
उधर एक
Bismillahirrahmanirrahim. Mr. Chairperson, Honorable Ministers, DG, WHO, Excellencies, ladies and gentlemen, Assalamu alaikum and a good morning. I feel deeply privileged to be representing Pakistan at this August Forum. Pakistan's journey towards universal healthcare is underpinned by our immense sense of responsibility and commitment to achieve health for all, by all, and at all cost. I consider health for all not a health sector's responsibility, but everyone's business. That includes government, civil society, development partners, politicians, private sector, and local communities. This whole new approach to health is not only the best way forward, but the only way forward. Let me congratulate RDMRO, member states, and WHO team for pioneering this approach in the region. Excellencies, the bitter reality of life is that it is ephemeral along with all its manifestations. Nothing is permanent except change. Today, we witness one expression of that reality when we all, with a heavy heart, would be bidding adieu to Mr. Mandari as Regional Director, WHO. Dr. Mandari has been an inspirational leader, an outstanding expert and a true humanitarian at heart. He has many laurels to his credit, but the biggest of all is the love and respect from all strata of the health ecosystem, and more particularly the Pakistanis, who had asked me to communicate their love and respect for you, sir. Mr. Chairperson, we appreciate and endorse the RD Regional Report on the progress, achievements, and challenges in implementing the Vision 2023, which has outlined key priorities and progress for enhancing access to UHC, tackling health emergencies, and ensuring health and well-being of everyone. We understand that the recommendations of the report would be critical for ensuring resilient health system for achieving the above objectives. Excellencies, Pakistan is signatory to the Astana Declaration and owns this in letter and spirit. In order to achieve UHC objectives, Pakistan made the following fundamental shifts. Pakistan became the first country in the world to adopt the Disease Control Priorities, Edition 3. Accordingly, an evidence-informed essential package of health services has been developed and at the national and provincial level and now being implemented. The UC Services Index in Pakistan has increased from 40 in 2015 to 52.6 in 2022. Let me appreciate WHO's catalytic support for piloting the PC-oriented model of care in our 2 districts. We are hopeful that it will turn out to be a replicable model. For building the capacity of PC system, a health facilities innovation exercise has also been initiated with the support of WHO. For other pillars of UHC, that's equitable utilization of health services, we have rolled out a universal health insurance program in Pakistan, which is the largest public sector program of its kind. This program is now being revamped so it can be scaled up, made sustainable, and uniformly implemented in the whole country. More value is being added to the program under an inclusive consultation process with the provinces and key health stakeholders. Just a few days back, we launched a mobile app, Mera Sehat Card, into that effect. Thank you. We have initiated a strategic shift in our priorities and would like to go from verticality into integration, from silos to collaboration, from stereotyping to innovation, and profit-centric to people-centric. Excellencies, Pakistan considered the implementation of international health regulation as a priority agenda, and for that, we have now organized a Global Health Security Summit in Pakistan on December 1st and 23. We already have sent out our invitations to all member states and the representative sample of all continents across the globe. And we would like your participation in that event so that we make it a new success. And that will set a new agenda for the global health security agenda in the whole world. Excellencies, thank you. We need to recognize the gravity of the new food and nutrition security and to invest in science, technology, integration, and innovation. I thank the worthy member states, WHO, and all other partners for their commitment and sustained efforts in advancing UHC and promoting health. Let me conclude by the motto of our GHSS Summit, Together for a Healthy Planet. I thank you all, sir.
निगरान वज़ीर सेहत डॉक्टर नदीम जान का आलमी इदारा सेहत की रीजनल कमेटी के इजलास से खिताब आप मुलाहिजा कर रहे थे। उन्होंने कहा कि सिविल सोसाइटी पार्टनर्स और तमाम शराकतदारों को ताउन करना होगा। WHO के खास तौर पर शुक्रगुजार हैं उनके ताउन के लिए। आज सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट पर समाअत जारी है, मुलाहिजा कीजिए।
The competence party, just give us your own time. Sir, I would like needless to state how many questions.
I'll finish in an hour, sir. If your lordship may kindly
so we can either take a break and come back.
Yes.
As is a good.
Article 10A has any connection with conferring power to the Supreme Court regarding appeal?
Sir, I would not like to go down that route that fundamental rights can be used in order to conferring legislative power, because fundamental rights are so widely worded that the entire legislative list will disappear if that interpretation is
10 past 2 we will convene again.
Sir.
10 past 2.
Thank you, sir.
Thank you.
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों की समाअत जारी है। चीफ जस्टिस काजी फायज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। इस वक्त समाअत में वक्फा लिया गया है। न्यूज स्टूडियो से फिलहाल इतना ही।